Good afternoon, good afternoon, good afternoon. Hello and welcome to Live with Just Us, Just Leadership USA's Facebook Live discussion series. My name is Hakeem Crampton. I'm excited to be your host. I am the Movement Capacity Building Specialist for Just Leadership USA. Just Leadership USA is dedicated to decarcerating the United States by educating, elevating, and empowering the people and communities most impacted by systemic racism to drive, amplify, and sustain the kinds of policy reform that builds thriving, sustainable, and healthy communities. Risk assessment tools are used at various stages in the criminal legal system, including pretrial, which is very important, sentencing, and parole and probation decisions to gauge someone's risk of committing another crime and therefore determining the nature of their incarceration and to what extent they should be released. Today, many advocates, such as myself, argue that these tools are based on data that is questionable, right? Does not accurately predict someone's actions and perpetuates racial disparities. So it's critical that as advocates that we have this conversation leading into a broader conversation to push for policy change. So I'm excited today to have with us a distinguished panel of speakers and experts in the field who are here to lend their expertise, their experience, and their knowledge to this very important topic. Today, I'm excited to be joined by distinguished civil rights attorney, Cynthia Conti Cook. We are also excited to be joined by Kelly Roberts Friedman, who is a research associate at the Urban Institute. We are also very excited to be joined by Maurice Dyson, professor of law at Suffolk University Law School. And lastly, and the distinguished of them all today on our panel, I can't wait to hear him, Sean Hill, assistant professor of law at Ohio State University, Moortees College of Law. Welcome, 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 everyone. And thank you for taking time to engage us in this very, very pivotal, important conversation as we are on a crusade to decarcerate America and fight for the liberties and freedom for people in this country who have been most marginalized, most impacted, who have never had a voice in the platform. And today they have a platform. Today they have a voice. Through each of us today, we have an opportunity to lend our expertise to the voice so needed at this stage to push for policy change and ultimate legislative change that will help change and shape the lives and reshape the lives of many people and families impacted. So thank you all for joining us. And thank you all to the entire audience joining us live on Facebook. Welcome everyone for joining us. Thank you so much. Those that are joining us via YouTube, thank you all. Welcome to this live Just Us conversation, important about risk assessments. Our panel have been introduced, and I would like to get right into some questions to give them an opportunity to really get right into the conversation. We have a series of questions that some of us have been wanting to ask, right? A group of panelists such as yourself, but haven't had opportunity to have a distinguished group together at the same time to ask these questions, because risk assessments, when we talk about them at pretrial to determine bail, for example, or to determine when someone is ultimately released from jail, we haven't had this conversation in communities often. There's been a lot of research, that conversation has been there, but we haven't had this conversation at community level. So these are the types of questions that we've been wanting to ask, and here we are, we have you. So let's jump right into some questions. First, why were risk assessment tools initially created and adopted, right? Since then, what has been the impact of risk assessment tools on incarceration rates? Does anyone want to tackle that?
Well, I can begin. I would say that the impetus for the risk assessment tools being developed in the first place was to develop an alternative method to judicial discretion. The idea that there was discretion by judges used in sentencing that could lead to disparate impacts led to the conclusion that we needed to have an objective basis for making decisions based on neutral characteristics that, again, were purported to be related to criminality. Now, that in fact has not been the case at all. In fact, the risk assessment tools have actually replicated the kind of bias that we have seen throughout the criminal justice system. When we look at what the factors that are used in determining whether one is deemed to be dangerous, we look at the age, we look at sex, we look at geography of the birth, the parent's marital status, the parent's level of education. We look at the crimes that are committed in the zip codes that the person lives in. All of these things, if you notice, have nothing to do with conduct of the actual defendant. All of these things, if you notice, have no bearing on that individual person's culpability. The idea that you can be held responsible for factors which you have no control over. You can't control where you were born, where your parents were, what crimes were committed in your neighborhood. You can't control those things. And yet to attach high stakes consequences to that, where there could be deprivation of liberty interests, to deprive someone of their liberty based on characteristics of which they have no control, it is in fact one of the fundamental unfairness doctrines that we recognize in constitutional law. This idea of nefarious discrimination based on immutable characteristics applies just as well to these characters here, and they are vulnerable for that reason.
Wow.
Yeah, I'll jump in just quickly. I think Professor Dyson is absolutely correct in his assessment. I would add that there are two ways that we can conceive these instruments in a historical sense. So one is that you can look at them as, okay, here, when was the first time that we had criminologists, folks in the criminal legal system correlating certain factors about a person with particular outcomes, right? So based on their criminal history, what was going to be the likelihood that they were going to be rearrested, recidivism, et cetera. But we can also conceive these instruments as being within a long history of crime data and statistics being utilized against Black communities, right? I'm going to probably be making a couple of book recommendations over the course of today's discussion, but Condemnation of Blackness, absolutely fantastic book by Khalil Muhammad, where he primarily looks at, in the wake of the abolition of slavery, you had a number of white criminologists, white race scholars who were utilizing statistics and data, whether it was arrest rates, incarceration rates, death rates, right? We started to administer the census in the wake of the abolition of slavery. So these host of scholars were using crime data to justify the quote unquote inferior status of African Americans, of Black Americans, as well as to deny social services to Black communities and supply those social services to white communities and newly immigrating Europeans. So one, we can conceive it both as historically fitting within this long history of crime data being utilized to justify the incarceration of Black and brown people. And then we can also look at it as a specific tool that identifies, again, these correlations, these probabilities. And as Professor Dyson referenced, we've had them for quite a while. They were first introduced in 1935 from the Illinois Parole Board. So introduced as a way to determine whether or not folks should be released to parole. So since 1935, we've had these instruments. And I think it's important to note that despite arguments that they correlate with reductions in incarceration rates, we need to note that we've had them since 1935, which means that we've had some manner of these instruments through the massive explosion of incarceration in the 70s, 80s, and 90s. And so I just want to direct people's attention to both that history, as well as to the fact that despite the claim that they can correlate with reductions, we've witnessed their use alongside, expansions in surveillance and expansions in incarceration.
Wow. Powerful, powerful. Thank you for adding that. Does anyone else want to conclude on that question before we move forward?
I'll just add one quick thing, which is that triage is also a reason that risk assessment tools have been introduced traditionally. And triage, normally if you're at a hospital and you're going through triage, it's because they have a limited number of doctors that they can have everyone who walks through the door see. For risk assessment instruments used in the criminal justice system, it almost seems like the scarcity is not in how many beds that there are in jail cells. It hasn't, as Professor Hill just talked through, it hasn't meant that we have limited the number of people going into detention or going into prison. It has actually been used as a way to limit the number of people that have been released.
Wow. And that perspective right there, that point gives a greater clarity to what we're talking about. So let's talk about some real examples of the impact, right? What has been the impact on individuals? And I can kind of lead with an example of this gentleman here by the name of Sean Tate, who is currently incarcerated. It's been going on close to 3 decades now. And what's been keeping him incarcerated now is the risk assessment that's determined that he's not fit to be paroled as of yet, right? And so that's one example of how individuals are directly impacted by a risk assessment. Let's talk about that. Share with us some of the other direct examples so we can get into the nitty-gritty how this is impacting communities.
Well, there was an instance in Wisconsin where the prosecutor and defense counsel actually would agree to the sentence that should be appropriate in the case. And yet, as a result of the recommendation of an algorithm, the judge exercised enormous deference to that recommendation by this algorithm. And in fact, what happened is that the defendant received a greater sentence from 2 years to now having 2 years with 3 years probation as well. And again, the idea of extending that time in which there is, again, state surveillance and a conditional release is, again, a direct consequence of this. Now, when a judge forfeits their own discretion in ways that defer so much to the algorithm recommendation, that's an abuse of discretion. And that is a fundamental problem that we've seen, where individuals will receive a larger sentence, they will receive a greater sentence, they will receive a great deal of negative connotations that are applied in the bail hearing when it comes to flight and risk. When we look at all of the interactions within the criminal justice system, when one interacts with that, these algorithms have had a direct impact in actually extending these sentences and making them harsher, and not necessarily exposing them to any kind of transparent scrutiny, because they are so opaque, because these private algorithms are developed by private companies that assert trade secret privilege. They don't want to actually release all the factors and considerations that go into these risk assessment recommendations. And that itself is problematic. So, we see some serious concerns about this. In 2016, in Wisconsin versus Loomis, the defendant was able to raise the issue of due process there. The idea that there should be some transparency in the considerations that went into the risk assessment score that actually led him to receive a further sentence for his crime. And the judge agreed that that would be a violation of due process. Again, these are considerations that we're seeing all across the country, but they are having an enormous impact in terms of actually exacerbating racial inequality, exacerbating the mass incarceration crisis that we see today.
Wow, powerful. Okay, Professor Dyson. So listen, I'm just a common person, and I want to help this cause. And I hear you say, that they're using algorithms. Define that for me. What does the algorithm mean in this regards to this risk assessment? What does that mean?
Well, it's a formula that is based upon predetermined factors in order to determine the risk of recidivism that a person might face. That is the possibility that they might commit crime again in the future, based upon, again, the kind of arbitrary characteristics of which a person has no control over, or being included in a sample which is not necessarily conducive to any probative analysis of that individual's ability to be able to conform their conduct in terms of the dictates of the law. So the idea that we are not actually really addressing the critical issues that have given rise to this crisis, the idea that these algorithms are kind of criminalizing poverty, they're criminalizing race, they're criminalizing the conditions in which we find BIPOC people, that in itself is a basis for, again, going to the ACLU, going to the Advancement Project, going to the Innocence Project, going to civil rights organizations, trying to seek remedies where you can to get full disclosure in terms of the validity, the accuracy, and the bias of these formulas that are being used, that you have a right to full disclosure of that. And of course, to be able to challenge that effectively, you need to be able to have full transparency of who actually developed these algorithms, what data that it is trained on, because this data itself, as we would say, is dirty data, as Rashida Richardson and others have said. This idea that we are basing data on policing practices that have themselves been biased, that there have been this broken windows theory of basically going after the small offenses in the hopes of curtailing the larger offenses, when in fact, in reality, that has just been an excuse for more extensive racial profiling. In these cases, we recognize that this is doing a manifest injustice to defendants.
Wow, and that's powerful. Thank you for that, Professor Dyson. Does anyone else want to add to that question before I go to another?
I was just going to add an illustration of what Professor Dyson was talking about when he mentioned trade secrets being an obstacle to understanding how these systems work. When I was an attorney at Legal Aid Society, on the request of someone who had just been denied parole, partially in part based on the risk assessment outcome, They wanted to know for an instrument that was used to determine someone's readiness for release from prison. When the person who is being interviewed is interviewed by their counselor, there's a bubble that pops up on the screen when when you hover a mouse over the screen, and there's like extra information that pops up in a bubble. That person wanted to know what the counselor was seeing on that software from that instrument. And so we did a FOIL request, a Freedom of Information request, to the prison saying, we want the training manual that your counselors are trained on this instrument with. They claimed that was a trade secret. We eventually won that case. It was not a trade secret, but that is the type of argument that they're throwing up every single time there's any attempt to learn about what's actually in the ingredients of these instruments.
Wow.
And I would just add, so there's a lot of, and I'm getting some of these great questions about this lack of transparency. So yes, we should both be criticizing these companies who have a host of interests with regards to why they don't disclose this information, but we also need to be very mindful of criminal legal actors themselves. Professor Dyson just referenced the Loomis case in Wisconsin, where you had this defendant wanting to have some idea of how his risk score was calculated, and what was disclosed in the dissent, a concurrence. So this was a judge that said, I agree with the ultimate outcome, but reach it for a different reason. But you have a concurrence issued by one of the judges for the Wisconsin Supreme Court, where that judge says, I encouraged my colleagues to find out the information and accept a brief from the company that will tell us how these risk scores are reached. And my colleagues declined to accept that brief from the company. And instead, what you see in this opinion that they issued is the judge is saying, well, based on our own analysis of, the literature around these instruments, we have reached the conclusion that they can continue to be in use so long as there are certain cautionary statements that are made to judges. So we both have the companies themselves that are invested in keeping this information unavailable to the public, but we also must absolutely be mindful of a host of criminal actors, particularly judges, who are also obstructing and interfering with the ability of the public to understand how these scores are calculated and how they reach their recommendations.
Yeah. And I ask another question. Does the public have a right to know, right? Do we as a public, what is our interest in knowing, and how does knowing empower us?
I think it's clear that when you're looking at, a state that does not actually, become transparent with their formula is in some way engaging in obstruction of justice. I do believe that there should also be, full disclosure in FOIA requests. And I do look at the idea that when it comes to liberty interests, and even to the point where we are looking at liberty interests versus property interests of private corporations and protecting their trade secrets and their intellectual property, that we have in other contexts have managed this, right? We've had confidential judicial conferences and camera review, in-camera reviews, behind closed doors in the judges' chambers, where we can actually look at information that may protect what privacy that the company may have, but it should never come at the expense of personal liberty. Right, that it should never come to the expense that if someone is being deprived of their liberty, that they should have the idea of fully being able to confront this information. We recognize in the Sixth Amendment that the Confrontation Clause that you have the right to confront your accuser, that you have the right to be able to look at the statements that are being used against you. This data has a kind of testamentary kind of impact. We don't always have a full resolution on this in the circuits, in the judicial circuits, but we recognize that. And to some extent that this is actually implicating, right, the defendant's culpability in some sense. And therefore, there should be some pushback to be able to review that determination, to be able to look at those underlying characteristics and to see whether they are in fact valid. Now, the fact that you are using, arrest records doesn't necessarily mean that the person is a danger to society if you're looking at arrest records that deal with, with petite property theft. Right, so you want to make sure that you're not just looking at data, but that the data is validated for the purposes for which it is intended to be used, right? And that is used accurately and objectively by a whole host of human interactors who can actually have across section of viewpoints to bring into bear on the question. So I think that there's a lot that has to be unpacked there, and I think that when you look at due process, you look at equal protection, you look at the right to discovery, the right to have full disclosure and confrontation of the evidence presented against you, that these are all compelling reasons why we should actually have this data.
Absolutely. Powerful. Such powerful presentations, everyone. Thank you so much so far. Wow. I want to get to Professor Hill and get very specific again. Professor Hill, why don't you tell us and talk to us a little bit about the connection between risk assessments and the movement right now with bail reform, and share us your experience in this area.
Yeah, thank you. So what I wanted to do was to start, before I even talk about bail reform and risk assessment, let's talk about the landscape of bail and pretrial detention, because I think that oftentimes gets lost as we're talking about the alleged solution to the problem. So to give folks an idea, if you didn't know, so for nearly all crimes, okay, regardless of whether you've been charged with any manner of crime, the likelihood that a person who's been charged with a felony will actually be rearrested for a violent crime is 1 to 2%. I want to say that one more time. If someone has been charged with a felony, which is considered to be, right, an especially severe offense, the likelihood that that person will actually be rearrested for a violent crime is 1 to 2%. Also, half of the people that are currently being detained in jails have a lower chance of being rearrested pre-trial than many of the people who have been able to secure their release, right? These are what some of these empirical evidence-based studies in recent years have uncovered for us. So when we account for these two facts, the fact that we have about 500,000 people who are currently incarcerated pre-trial, presumptively innocent, they've only been charged with the crime. These jail populations are overwhelmingly Black and Latinx people. When we take these facts together, what it would tell us is that, one, judges have not been reliably predicting who is dangerous, right? That's what the data, that's what the figures that we have are confirming for us. And then two, that in addition to not reliably predicting who is dangerous, this has resulted in severe disparities along racial and class lines. So the response has been, let's eliminate monetary bail, right, to address these issues. And risk assessments become this kind of straightforward, easy solution, right? They're going to get us away from reliance on monetary bail. We're going to supply judges and prosecutors with alternatives for identifying who's dangerous, so that they're not overly relying on monetary bail. So we have this, right, response, eliminate monetary bail. And I see the problem being twofold when it comes to risk assessment and bail. The first problem I see is, one, us not really interrogating or forcing stakeholders to answer the following question, which is, one, why should we be investing money to quote unquote improve risk assessment if arguably that's not what judges have been doing, okay? Why, in other words, are we not questioning how a practice that did not actually correlate with public safety persisted for so long and demanding answers, right, of these stakeholders? What does it tell us about the actual objectives of the criminal legal system? And then two, the second problem I see is because of the emphasis on monetary bail, which is understandable, right? It is hugely responsible for why so many low-income folks are incarcerated. It's accessible, it's easy, right? It's a great slogan, great campaign. But because of the emphasis on monetary bail and the lack of emphasis on the criminal legal system as a site for targeting and controlling non-white people, advocates ultimately opened the door for new mechanisms of control, and that's how I conceive and frame risk assessment instruments. And I'll close these quick remarks, but ultimately I looked at New York and California. So prior to transitioning into teaching, I practiced in New York for about 6 years, and during my last year in the city, I was involved in the bail campaign. And it's meaningful, right, that even though there has been a rollback of the bail reform in New York that I'm sure Cynthia can speak to, it is deeply meaningful that New York was, one, able to prevent judges being authorized to predict dangerousness. Now, New York remains the only state that preserves the traditional purpose of bail, which is to ensure you come back to court, right? So one, advocates in New York, even though they kept monetary bail intact, this has received attention, even though bail reform was rolled back. Before those rollbacks, there were tremendous reductions in populations, particularly in upstate New York, and this was despite monetary bail still being intact. So one, I want to challenge us to have a nuanced understanding of this issue, right? It's not merely about eliminating monetary bail. It's about addressing the failures of bail to actually protect public safety, the alternative purposes of the criminal legal system. So we have New York on the one hand, and I'll end here, we have California on the other. California, as some of you might know, they passed bail reform in 2019, signed by Governor Jerry Brown, and advocates that had originally supported this bill, they withdrew their support at the time that it was signed, in large part because the original bill, which was supposed to facilitate large amounts of decarceration, getting plenty of people out, there was a closed door meeting between the governor, the chief judge of California, and they emerged with a new bill that was deeply reliant and dependent on risk assessment instruments, such that advocates that had originally supported this decarceral bill withdrew their support, joined with bail bondsmen in order to have a referendum placed on their ballot, and they reversed course and actually withdrew this bill that had received so much positive attention for eliminating monetary bail and introducing new, better mechanisms for predicting dangerousness and public safety, which were risk assessment instruments. So this is a landscape that is deeply in flux right now, but I think it really should encourage us to look more deeply at the host of issues of power, control, and domination that are at play whenever we talk about the criminal legal system, whether it's risk assessments or otherwise.
Wow, that's a great landscape, a great map for us to think about, such powerful information. And let me ask you this in follow-up, right? Say I'm just an average Black person that's poor, or another minority community, for example, from any marginalized community that's poor, and I get arrested. Am I naturally, by structure of the system, going to be assessed higher risk because I'm from a marginalized poor group? Is that what's going to really happen to me?
So we can't say, because every region is slightly different on the type of risk assessment they use, what that tool is going to utilize for its factors. But we talked a little bit just a while ago about transparency, right? What does it mean for communities to know what's going into the instrument, and can they actually influence, right, the types of factors? So of course we're going to be opposed to what you're naming, which is utilizing someone's zip code, utilizing someone's maybe race, obviously, right, demographic information. But what we have to note is that even if we take out all of these hosts of things, we get transparency, we say, well, we don't want you utilizing someone's zip code, we don't want you utilizing whether they've had any type of foster care involvement, et cetera. Ultimately, regardless, a risk assessment is always, in the criminal legal context, it's always going to require looking at criminal history. And criminal history is not this objective marker of a propensity for crime or violence, but we're always relying on the criminal history. And because criminal history has been so deeply influenced by race, right, by disproportionate arrest and incarceration, it's inevitable that we're going to have, right, these biases of the past continued into the future. And as Professor Dyson said, we've had Rashida Richardson right on this subject. And then there's also Sandy Mason making the insight, right, that if you're putting biased information in, it's all inevitably going to have biased information as outputs as well.
Wow. Thank you. Now let's look at it from the mind of an attorney. All right, Cynthia Cook, tell us, who is this tool really designed for, right? What type of data is it asking? And what is the data, and how are these tools really procure? Like we heard some information, Professor Hill and Professor Dyson, about some of the types of questions and the data that's pulled, but who was this risk assessment really designed for? Like, tell us.
Yeah, it's going to be different. As Professor Hill said, it will be different for every tool used. We see something like a risk assessment tool used in everything from predictive policing to bail determinations to sentencing, sometimes programs that are alternatives to detention determine eligibility, whether you can get into that alternative program based on a risk assessment type of tool. So it depends on who is making the decision that is ultimately supposed to be guided or assisted, or if their discretion is supposed to be cabined in some way by a tool. But how they are created and what the relationship is to the person who is ultimately responsible for the decision they've made is really important, because our ability, for example, to hold judges accountable for the decisions they made typically happens through the appeal process. The appeal process is limited to what can be read on the record. As I think Professor Dyson said earlier, if we are not able to put the model or the equivalent, to the model on the stand and really ask it questions about how is it coming to the conclusions it's making, we're not able to generate that kind of record for an appellate court to review, to hold that judge accountable for that decision-making process. And judges themselves have their own algorithms in their heads that are sometimes impenetrable and not always produced on the record clearly either. But what this actually looks like in a courtroom is, for example, in a sentencing hearing for a young person in New York City, if the probation officer who has made the sentencing recommendation based on a score sheet, based on a risk assessment tool, is on the stand, and the young person's attorney is asking them questions about how they came to their determination, what this looks like in a courtroom is basically that person just answering the question, I don't know. The tool came to that determination. I just followed the grid and found out the recommendation should be blah. But they don't have an analysis for how that tool came to that conclusion. And without the judge agreeing that the tool should be opened and examined to figure out how it came to that conclusion, it's very difficult for an attorney to actually get that on the record. And therefore, holding judges or probation officers or any type of person that's using this accountable is very difficult. Another example, again, from the New York State prison system that uses the COMPASS instrument to determine release eligibility, there's a question on that questionnaire that asks, it's question 19, that asks whether a person has a notable disciplinary history. What does that mean? And for many men that I've spoken to who have been in prison for decades since they were teenagers, their disciplinary records look very different in the past decade than they did the first decade that they were in prison, right? And so what does that mean for a counselor asking a question like, does this person have a notable disciplinary history? And then how does a person hold that counselor accountable for answering that wrong? Through a grievance process? I tried to help several people in this situation, and the grievance process ultimately was frustrating and didn't result, even if they won their grievance, didn't result in the COMPASS often being corrected. Glenn Rodriguez has talked about this in, I think, documentaries and in a few articles online. I think one published in the Washington Monthly. But those are the types of decision makers who these tools are being created to either cabin their discretion or to attempt to cabin their discretion, or to really cover up what is already bad decision making by saying that there's an objective tool. I've heard data scientists literally say to a group of people in the justice system that these tools are based on science, and therefore we should all believe them and just trust that they're doing the right thing.
Wow, thank you. Kelly Freeman, let's get you in on this conversation. So listen, let's talk about some research and whatnot. What is it showing about what's happening? What Cynthia just talked about, what's happening at that sentencing process, right? So say, for example, there's a judge who's receiving a recommendation from some assessment or evaluation, right? Pre-sentence investigation report or whatever the case may be. What is happening at this point? Is this some form of double jeopardy? Is the judge assessing and evaluating along with the recommendation? Does the recommendation present a secondary layer of bias? Like, what is being determined here based on this report? And at what level is the determination really having a biased impact on the person who's going to lose their liberty, perhaps?
Yeah, this is a really good question, and it's such a great panel to be talking about a lot of the implications of risk assessment tools being used. I think a lot of the sort of high stakes decisions that are based on sort of the assessment tools that are being implemented are actually occurring regardless of whether a risk assessment tool is in place or not. So you mentioned pre-sentence investigations. Some of these reports that probation officers produce might be narratives. They might not necessarily have a sort of structured risk assessment information provided to the judge, or alternatively, they could also include information from a risk assessment tool as well. And so a judge, when they're looking at a pre-sentence report, will have a lot of information at their disposal, but may be relying more heavily, say, on a risk assessment instrument because they've been sold as sort of objective and more effective at determining who is a public safety risk, right? So a judge might rely on that more heavily in their decision making, regardless of whether there's other information, sort of mitigating factors within that report that would actually, lead to more leniency, maybe in sentencing, or in terms of probation, it might maybe in terms of their level of supervision. And so the tools themselves are implemented as sort of one of many factors that judges use in decision making. And I don't, mean to say that the tools are not affected by biases. They are. They're a part of our justice system. They're based off of data, of course, that everyone has mentioned on this panel before, based off of data that is measuring system involvement, right? They're not measuring necessarily just a person's individual actions or behaviors. They're measuring sort of what the justice system response has been in certain communities and in certain for certain types of offending. And so I think when a judge is looking at this, really the high risk sort of label that I think kind of produces this idea that somebody is more likely than not to engage in some sort of misconduct or violence, or to be more dangerous than another person, is not necessarily what the tool is even measuring. And so if it's not understood in terms of what the tool is actually measuring, and if there's not clarity around what high risk means, then that can lead to very detrimental outcomes.
So Kelly, is it a ruse? I mean, really, like, is the risk assessment tool just really a ruse just to really marginalize and penalize and keep people, incarcerated longer and locked up longer? Is that really what it is? It's just a ploy? I mean, what is it?
Well, so what it's often been sort of, I think the proponents would say, is that the risk assessment tool is more objective, right? That the risk assessment tool is based off of factors that have been shown, again, sort of empirically to be related to future justice system and contact and involvement. And so if you're looking at these tools and they're more effective or more predictive rather than professional judgment alone, then we should be using these tools. However, it depends on what the objective is. If the objective of the justice system is only to determine who should be released or who should be detained because of their future behavior, then a risk assessment tool can maybe help do that. But if the justice system is not geared towards really, deciding what level of risk somebody predictions in general are very challenging, even for risk assessment tools. Let me be very clear. Like, a risk assessment tool might not actually be predicting outcomes much better than professional judgment alone. But if it is, more predictive, are we okay as a society, as a community, with judges making decisions about someone's treatment, someone's incarceration based off of these tools? And that, I think, is a question for communities to really understand and to be able to weigh in on that. There shouldn't be sort of decision making that's based off of, from my opinion, I guess I should say, there shouldn't be decisions about someone's liberty based off what they might do in the future, or based off what a tool suggests is more high risk than another individual.
Mm-hmm. I understand. Yes, thank you for that. Thank you for that. Let's get into this one of the final questions before we take some more, where we take some questions from our audience members. And Dr. Dyson, let's get into this question here. Really, what legal strategies, can advocates such as myself or organizations in communities, what strategies can they take? And then a secondary part of that, though, like, and this could be a question for Professor Hill or for Cynthia. Who should we really be putting pressure on at the next level? Like what can we do right now, right, so to speak, legally? Like, is there any legal challenge we can make? And then to what long-term, advocacy campaign should we be pushing for, and who do we need to push it to what level, to all the way up to whom and to where?
Well, so there's quite a bit to unpack there. I would say that in terms of looking at legal approaches, I mean, Loomis lays out an idea that we should be challenging again these algorithms in terms of their transparency by, raising due process considerations. Due process under the Constitution requires that there be an opportunity to be able to review all the data and all the information that is being used, and to be able to prepare an effective defense, you need to have that data. So due process is quite clear. And equal protection is also quite clear, because there is a disparate impact that we've seen. When we look at the proportion of folks that have been labeled higher risk but didn't reoffend, that was 23% of whites. But for African Americans, it was 44%. When we look at the individuals that were labeled low risk but didn't reoffend, that was 47% of whites and only 28% of African Americans. That shows that we are really on the short end of the stick in terms of BIPOC community being treated fairly, that the Equal Protection Clause would be implicated quite obviously, because it has a disparate impact in sentencing recommendations, in bail recommendations, in looking at predictive policing patterns in communities, and recognizing that these have a disparate impact under equal protection for both race, for sex, and other protected classes. I think that's important to remember. There's other issues that we have to remember too. As I said before, I think a Sixth Amendment issue should be raised in the sense that some jurisdictions, not all, have recognized that this has some kind of incriminating aspect to it. So both the right to be able to confront the evidence under this Sixth Amendment idea, and to be able to raise a right against self-incrimination, having this this data to be used in any kind of determination. These are long-term strategies that we need to really kind of pay attention to and look at. And then I think we need to also kind of be mindful of addressing these companies as well, that we have to recognize that we can pierce the corporate veil, and when we see fraud, we can pierce the corporate veil of companies in a way that limits their ability to be able to immunize themselves from any kind of legal challenge. Right? If we can say that in some context that these companies can exist with these trade secrets, we have to recognize that in trade secret law, we still have other avenues and mechanisms for which we can challenge any kind of determination, while at the same time making sure that other interests might be protected. But in a sliding scale of things, remember that liberty interest is paramount. That matters more than property interest. And we've seen that assumption at least built into other aspects of our Anglo-Saxon law. So it should apply here no less. The other aspect of this is that you're being tied to association, right? That, if I grew up in a very rough neighborhood. Most people that I graduated from high school actually are in prison or dead. But the statistics that I grew up with would make me be considered a dangerous person. And if that can be attached to someone who is, a law professor who has, gone down the path where they have been able to show their potential, then for those who have had their potential cut short, based upon these same characteristics, it's just, again, it's nefarious discrimination that it's on basis of immutable characteristics that is problematic. That, part of this is also that we have freedom of association, right? The First Amendment of the Constitution recognizes that we have freedom of association to be able to associate with who we wish, and not to necessarily be penalized with whom we do associate with in our communities, because they happen to be our neighbors. They happen to be the people that we grew up with, and that is not necessarily any kind of probative assessment of my own possible recidivism. That's just not unfair. That's just unfair under the First Amendment of the Constitution, under the freedom of association. And then, as I said before, when we think about the serious implications of this, we have to think about this broader, right? Risk assessment tools have been used to kind of incarcerate, to increase penalties, but these risk assessment tools really trace poverty and race. And they can be used to maybe target better beneficial resources to those communities that are needed the most. In other words, you don't have to use these risk assessment tools in a way that is going to continue to perpetuate mass incarceration and the underlying discrimination that we see systemically. We can use risk assessment tools, if we're going to use them at all, to actually be beneficial to help the person to be reintegrated back into society, right? To have more of an empathy used to this, is recognizing that the restoration and rehabilitation of the individual is paramount, and that the kinds of things that we see in terms of crimes committed could very well be the natural and probable consequence of 400 years of slavery. And so when we look at the prison industrial complex maximizing this idea that there is profits to be made, or that there is this bodies to be fed to prisons through probation, these are things that have to require a broader change, where we say we need to rethink policing. We need to rethink the idea of even using assessment tools in the first place, and certainly if we are going to use them, to use them positively. But I think even more broadly is the idea that with such a systemic history of racial discrimination, it's just not possible to be able to outsource our discretion. And the fundamental abuse of discretion is advocating that to an algorithm. And that is also another Fifth Amendment consideration. And it's also another due process consideration. And it should be for every judge and every jurist that does do so, would be found to, again, be improper for their judicial temperament and for their willingness, again, to advocate their discretion. Again, that is a matter of professional responsibility that we should take on seriously as attorneys. But I am all for class action suits. I do think that these systemic changes need to be made, but recognize that algorithms, facial recognition technology, all of these are an arm to continue to do what the system has already been doing for centuries, and it has not changed, and it's only making it worse. So looking at the impact is what matters. Well, you can say that that's not the intent, that that's not the purpose, but the impact has to be part of the equation. And our constitutional analysis can't just look at the defendant's intent, it has to look at the impact on the victim. And that is a fundamental sea change that we need to take into consideration in our constitutional jurisprudence. And that's what we need to push for in our legal reform challenges.
Wow. And I'm sorry, I know we have, I would love to hear, seeing these fabulous comments from folks. Mm-hmm. I just want to add a note on the policy campaign front. Professor Dyson has spoke very much to the legal strategies that we can be pursuing. I think on the policy front, particularly when we account for the differential progression of bail reform in New York versus California, I would recommend, first and foremost, for policy campaigns, this is happening both at the state level, but also, we're witnessing at the federal level in real time, the introduction of new criminal policies that allegedly are going to address the disproportionate arrest and incarceration of Black and brown folks, but in reality are ultimately not going to necessarily do a good job in that realm. So for policy campaigns, I would really recommend that folks, one, we have this emphasis on monetary bail, and I don't think that that necessarily needs to end, but rather I would really encourage policy campaigns to focus on their bottom lines, which are, we want dramatic reductions in pretrial incarceration rates. These are presumptively innocent people. According to the Constitution, there are supposed to be certain guarantees for those individuals. Given those facts, we want dramatic reductions. And ultimately putting it on stakeholders, I think campaigns can obviously have their own proposals, their own recommendations, but ultimately engaging in assessments of proposals from these legislators, from these politicians, engaging in a response, an analysis that is, but is this going to get us to dramatic reductions in the number of people that are detained pre-trial? I think that New York did a good job of that, constantly emphasizing that what the end goal was. And I think that ultimately prevents monetary bail, risk assessment, or any new types of interventions to be introduced that are just going to recreate the same problems. And then finally, I'll just end on this note. I'm seeing a lot of notes about changing some of the factors that these tools use, designing them in a way that actually rectifies, resolves, addresses these long-standing problems of targeting low-income Black and Latinx people. The thing is that for that to happen, we would have to have a dramatic transformation in where power resides in our society, right? That's not oftentimes the conversation that stakeholders want to have, which is how do I, as a member of a community, as a Black person, as a Latinx person, how do I possess power? Because I'm instructing you on particular solutions that I want to see, like dramatic reductions, but these are never considered actual legitimate proposals, right, from our communities. So I think that in order for us to move to this realm of communities that are actually impacted, being able to influence how these tools are used, we have to have a deeper conversation around who possesses power and how our criminal legal system and a host of other areas, whether in housing, employment, ensure that certain communities remain powerless, meaning they're not going to be able to influence legislators in the ways that are going to rectify these harms. So I'll end it there, but yes, I think main takeaway is policy campaigns should be really clear on what are their objectives, what is it that's the end goal that you're trying to reach, and it may not necessarily be ending monetary bail, because you can end monetary bail, as California demonstrated, you can end monetary bail, introduce risk assessment, and then still have the same rates of pretrial incarceration or even increased rates of pretrial incarceration.
That's a critical point there. Definitely. Thank you for that. Now, we have a series of questions that's come from our audience, both from Facebook Live and YouTube, and they appear in our side panel chat for us here in the panel. Is there any question there that stands out to any of you? I see some great ones, but I would like to know if there's something for you that stands out that you'd be able to answer with expertise on.
I think there's a question here about universities playing a role in creating risk assessment tools for states, and I think that's that's a serious concern, especially if it's a university that is a federal fund recipient. That they are engaging in this kind of work should be a violation of their Title VI obligations, right? The Title VI of the Civil Rights Act of 1964, and Title IX. All these civil rights statutes apply to federal fund recipients of universities and colleges that engage in this, that should be a violation if they do engage in this type of work. But for private institutions, of course, that fall into these protections, we have to be mindful of the fact that we can be, we can have agency outside of the legal system. And I think Professor Hill, mentioned that the policy aspect is besides the legal challenges, but the idea is that we can bring transparency to these discussions and make sure that the public is aware of these, right? So that we can use our power as consumers to use our consumer power in ways to be able to vote with our dollars to decide where we want to put our investments. Do they reside with companies that engage in the prison industrial complex and that advance that through use of these risk assessment tools? Or can we divest of those kinds of structures and reallocate those resources in more beneficial ways to our community? I think that is key. But for a college or university to engage in this kind of venture, I would hope that they would be as transparent, that they would be very clear and accessible about what their role is, how they are contributing, because otherwise we are just replicating the problems that we've already seen if we do not.
Absolutely, absolutely. So we got about a time for maybe one more question from our audiences that we may have about 60 seconds for, and then we can do a final wrap up and final thoughts. Is there any other questions there that any of you panelists see?
Go ahead, Cynthia.
Sorry, I was just going to recommend, in terms of some of the research questions that seem in the nitty gritty in the chat room, I would love to point you all to Mapping Pretrial Injustice, which is a fantastic website that was organized by, I think, Media Justice and Movement Alliance Project and a few other groups. There's an entire very long list of research papers organized by sort of topic. And so that would be a really great place to go to answer a lot of these really in the weeds questions that I think, based on the questions, you all seem interested in. I would also just absolutely agree with the focus on impact as a way to measure what's happening in your community. If you're watching a risk assessment instrument be used and you want to understand, how it's working, whether it's working, is really just to look at what is it actually doing. I think that the other types of questions to ask yourselves when you're deciding whether or not to organize around a risk assessment tool is, who is the tool helping, or who is it making a decision for or with? If that's a judge, if that's a probation officer, if that's a counselor of some sort. And then also think about what outcome is the data being asked about, and what data is informing the model. Those are the types of questions that can help you unpack the ways in which this tool may be unfairly being deployed. And then, in addition to what impact is the model having already in use, like for the decision maker, it's supposed to be helping. For example, are judges really having a hard time predicting who is getting released? Is that the issue that we're facing? I know in New York City, the issue we have much more often is that judges are afraid to be on the New York Post the next day. And that is much more of a consideration than whether they are statistically probably answering a question correctly. The last thing that I just wanted to say is that I don't think we should throw out the science with the bad policy. Risk assessment tools are terrible policy, but the actual science that they use is something we could use as a diagnostic tool to help us understand bias in our criminal justice system. And that if we just faced it in a different direction, it could actually be something that that we benefit from. But I would say organize is the way to do this. It's in the courtroom. All of the arguments that Professor Dyson laid out are very hard to make in the middle of a bail hearing when things are moving very quickly, for example. There's because of how these decisions are deployed, they're deployed in moments within a case. And to interrupt that moment with constitutional arguments is a decision about delaying the rest of the case. And it's very hard in some of those circumstances to do so.
Wow. Thank you. And I've learned so much from you all. And I've been learning as much as I've had a direct experience with being biased by risk assessments. I've been learning so much because there's so much involved in this conversation, so much research needed. And so on these final thoughts, this is pretty much, we're going to wrap up, and we need to call to action. We need to really figure out, what are our real next steps in this movement to not only educate our communities that are most impacted, right? But how do we take action in changing these policies in these various states around the United States that is really going to reduce the usage of the biasness that is inherent in these risk assessments? And so, in final thought, Kelly, give us a final concluding thought, and point us in some direction. Where do we go from here?
Yeah, I think that's a really great question. And there's a lot of really good ideas, I think, that have already been touched on a little bit already. But I think that one thing to really take away is that decision makers who are using risk assessment tools really need to consider how these tools were constructed, how they've been, what information is going into them, what they're trying to predict, and what the purpose is for their use. So when they're implementing a risk assessment tool in practice, they have to know sort of what the limitations are and whether or not they, are going to be important in terms of what objectives that the agencies themselves are looking to achieve. If they're looking to reduce incarceration, if they're looking to address racial disparities in the justice system, are these tools achieving that? Are they actually operating to support those, those outcomes? If they're not, then they need to be either revised or discarded. So I think that's really the key, is like, what are the objectives of the system are? Is it what the community wants? Is it what is equitable? If it's not, then I think that ultimately would have significant impacts on whether or not the tool is used. And I think that their use for pretrial purposes is quite different than what they are used in terms of making decisions about sort of treatment or other interventions. And so, I think there's ways that they could be changed potentially, but that really depends on what the objectives are for their use.
Thank you, Kelly. Thank you so much. Thank you all, distinguished panelists. It has been a tremendous honor having this conversation with you, learning from you all, and helping us and our Just Us campaign, as we really push to really help change the direction in which our nation has been moving to incarcerate so many people. This is truly a carceral state, and Just Leadership is committed to decarceration, right? And that doesn't only mean by getting people home and getting prisons so-called closed, but it really means providing the necessary tools that communities need to thrive after we've had such traumatic impact with such a very egregious system that has plagued this nation for the last 400 years. So once again, thank you. And my distinguished friend, Mr. Sean Tate, locked up in the state of Wisconsin Department of Corrections, also thanks you for sharing this critical information. He has currently filed a suit in the state of Wisconsin, alleging violation of his constitutional rights to be free from the usage of this risk assessment tool in determining his liberty. And that's what the heart of this conversation is about how do people have a real, fair, adequate chance of earning their freedom and liberty without the biasness, particularly racial biases that come into play with the criminal justice system or the criminal legal system, the criminal punishment system, as it's been called in so many different nuances. And we all are working in solidarity together to fight to end this carceral state. So once again, thank you all, distinguished panel. And I salute you all as we close out and conclude this conversation. Thank you to the wonderful audience that has joined us on YouTube and Facebook. Thank you, and so long. Till next time.
Thank you.